welcome to the debate. Today, we are examining a massive geopolitical chess move, specifically Cambodia's sudden decision to invoke compulsory conciliation under the UN Convention on the Law of the Sea, or UNCLOS, to settle its maritime border with Thailand.
Right.
And I am arguing that this unilateral shift, away from decades of bilateral talks, is a destructive diplomatic escalation. It shatters mutual trust and basically destabilizes the region.
Yeah, and I take the opposing view here. I argue this is not an escalation at all. It is actually a highly practical, structured application of international law, and it is designed specifically to break a diplomatic stalemate that was, frankly, going nowhere.
Okay, let us get right into the mechanics of why this is so disruptive. For over 2 decades, Thailand and Cambodia have relied on bilateral frameworks, specifically MOU 44.
Which was signed back in 2001.
Exactly, 2001. It was meant to guide joint development of the overlapping maritime claims area. But by abruptly abandoning MOU 44 and forcing this international UN close mechanism, Cambodia essentially told Thailand, their mutual trust is dead.
I think dead is a bit strong, but...
Well, Thai Deputy PM Saya Hasak Kit Kao rightly expressed profound disappointment. This maneuver halts broader cooperation, it stalls joint efforts to open trade checkpoints, and it freezes critical negotiations on border security.
But we have to ask why Cambodia made this move. I mean, you mentioned 2001. MOU 44 has existed since then, and yet the overlapping claims remain completely unresolved.
Well, these things take time.
Sure, but bilateral talks had fundamentally hit a wall. And when you hit a wall, you need a ladder, right? Invoking UN CLOSOS is that ladder. Cambodia triggered compulsory conciliation.
The compulsory part being key here.
Right. Unlike voluntary conciliation, where both sides have to, agree to participate, the compulsory mechanism means Cambodia can legally force the creation of an independent commission whether Thailand likes it or not. They have already advanced the process by appointing their 2 members.
A Danish diplomat and a French marine law expert, which of course forces Thailand's hand. That is exactly the issue.
It forces a process, yes. But we need to understand how this mechanism actually works. The resulting UNCLOS ruling is not legally binding.
Wait, really?
Yeah, it doesn't draw a final mandatory border to punish Thailand. What it does is provide an objective 12-month framework. It brings in outside experts to examine the facts and issue a report, creating immense diplomatic gravity that establishes a factual baseline for final negotiations.
I understand the technical distinction, I really do. But think about the real-world mechanics of this. It is like bringing in a court-appointed auditor to publicly examine your business partner's books because you stopped trusting them.
Okay, that is one way to look at it.
And then you still expect them to casually co-manage the store the next day. The sheer act of forcing the audit ruins the working relationship. And you mentioned a 12-month framework, but precedent suggests otherwise.
You mean the timeline?
Right. Look at the Timor-Leste and Australia case. That compulsory conciliation dragged on for over 2 years.
That is a fair point on the timeline, I will admit. International legal mechanisms are rarely swift.
Exactly. And while these European legal experts sit in boardrooms arguing over maritime baselines, the delay immediately inflames ground-level military tensions. We are already seeing the fallout.
Are we?
Yes. The Thai 2nd Army Region Commander just made an urgent deployment to inspect border troops in Surin. That visit directly coincided with the highly unsettling discovery of a Type 72 anti-personnel landmine right near a local sports field. You simply cannot separate diplomatic maneuvering in Geneva from boots on the ground in Surin.
I think you are conflating a broad diplomatic strategy with an isolated security incident.
How so? They happened at the same time.
Because the discovery of that Type 72 landmine was thoroughly investigated, and the evidence showed it was old, dilapidated, and likely transported from elsewhere. It was not an active new deployment triggered by an UNCLOS filing.
It still raises tensions, though.
But the physical threat is being actively managed by the military. We shouldn't frame a procedural legal maneuver as directly planting explosives on the border. Furthermore, look at how Thailand is actually responding legally.
under protest.
Despite their vocal protests, yes, they are actively preparing to appoint their own 2 legal experts to this 5-person UN-class committee.
Well, participating in a tribunal to defend yourself doesn't mean the mechanism is fostering a healthy resolution. It just means Thailand has no other choice.
But the mechanism is working. By forcing a non-binding but highly authoritative third-party review, Cambodia broke the deadlock. Both parties are now heading back to a negotiating table structured by international law, not endless circular bilateral meetings. Sometimes relying on an objective, third-party framework is the most viable path forward when direct diplomacy stalls.
It suggests that forcing international arbitration sacrifices vital bilateral goodwill for a protracted adversarial legal battle. So, we're left looking at 2 very different blueprints for regional stability. On one hand, the perspective that forcing a third-party legal framework shatters the fragile trust required to maintain a peaceful, cooperative border.
Right, and on the other, the view that when diplomacy hits a wall, an internationally structured baseline is really the only way to restart the engine.
Ultimately, whether international legal mechanisms help clear the air or permanently fracture the relationship between neighbors is a question you will have to answer for yourself.